All right. Hello, hello, hello. I hope everybody can hear me. Welcome back to the AI and Law Conference 2024. Thanks for taking the time to tune into the panel Bias in AI, Regulation as a Help or a Hurdle today. I'm really looking forward to this panel with top-class experts. We want to discuss the origin of discrimination through AI systems and the scope of legal protection in German and European law. We also want to take a close look at the internationally groundbreaking so-called AI Act in terms of its benefits and missed opportunities. Once praised for its supposed objectivity compared to human decision-making, algorithmic decision-making is now known for its susceptibility to bias in data on which it relies. Research has repeatedly shown that there are bias in AI systems that have tangible consequences in the real world. A machine learning algorithm that is prone to making unfair decisions can perpetuate systematic discrimination, as its decisions will influence a large number of future cases once it has been trained. The use of AI has the potential to violate fundamental rights, compromise privacy, and encourage discriminatory decisions. In various areas, such as personalized advertising, recruitment, credit scoring, and criminal justice, AI systems have a significant impact on individuals' lives and can both affect individuals and society as a whole. The issues of fairness, bias, and discrimination are linked to broader ethical and societal concerns, including transparency, power, autonomy, and accountability. Furthermore, these concerns intersect with privacy and cybersecurity considerations, further complicating the ethical landscape around the use of AI. We will discuss all of these topics just in a moment. Prior to our in-depth discussion, I want to take the chance to introduce our panelists. Afterwards, each panelist is going to give a short opening statement for about 10 minutes. This is followed by the discussion. And finally, you can ask questions and participate in the conversation. If you have any question during the panel, please write them in the chat and I will pick them up at the end of the discussion round. Now to our introduction of our speakers. First, Mark Rothenberg. He is the former and founder executive director of the Center of AI and Digital Policy. It was established to protect fundamental rights, democratic values, and the rules of law. They have built a network of more than 1,200 advocates and experts in 80 countries. Prior to the panel, we from Recall Law have asked every speaker the following question. Does the AI Act protect against bias in AI? Mark Rothenberg's answer to this question was, AI exacerbates bias across many sectors of our society: housing, credit, education, employment, and criminal justice. Governments must act to end algorithmic bias. Our next panelist is Gabriel Massini. He is the architect and lead author of the proposal on the Artificial Intelligence Act, the so-called AI Act, by the European Commission, where he has focused on the legal and policy questions raised by new technologies since August 2017. Before joining the European Commission, Gabriel held several positions in the private sector in New York and served in the European Parliament and the Court of Justice. He holds an LLM from Harvard Law School, a PhD in Italian and comparative criminal law from the University of Pavia, and a law degree from the Catholic University Milan. He's qualified to practice law in Italy and New York. Since January 2024, he's a Connection Science Fellow at the Massachusetts Institute of Technology. His answer to the question, does the AI Act protect against bias, was yes. One of the key objectives of the AI Act is to ensure that AI systems available in the EU market are safe and compliant, including with regard to bias and anti-discrimination law. Our third panelist is Celine Yakar. She is a PhD candidate at the Institute of International Private Law and Comparative Law at the University of Bonn, supervised by Professor Dr. Suzanne Leding-Gössel. Her research focuses on the risk of gender discrimination by algorithmic systems and whether the forthcoming EU AI Act will be able to mitigate these risks. Recently, she has developed and published a handbook alongside Professor Gössel on gender-neutral AI, in which they analyze the extent on how the problem of gender discrimination by algorithmic systems is addressed and treated by current national and international legislation. Her thesis builds on the insights gained by this previous work and examines the extent to which existing law not only addresses human discrimination, but also algorithmic discrimination, and how the EU AI Act is structured in comparison. Elaine said to our question, no, the AI Act does understand the significance of minimizing biases in algorithms to prevent biased decisions, but it does not create the necessary tools to actually be effective. Ayuha Burschat is principal researcher and deputy site director of the German Research Center for Artificial Intelligence in Berlin. He's an expert in language technology and artificial intelligence. He's also a senior research fellow of the Weizenbaum Institute for the Networked Society and deputy chairman of the Berlin Scientific Society. He was also a member of the Enquete Commission on Artificial Intelligence of the German Parliament. His answer to our question left a bit room for interpretation. It depends on what we make out of it. To quickly introduce myself, I'm Ramona Weber. I will be moderating the panel today. I was a former board member at Regulierung and have been a member ever since 2019. He was responsible for the conception and the implementation of numerous analog and digital events. And besides my work for Regulierung and other nonprofits, I work full-time as legal process manager at Hilfe in Berlin, with my main focus being on legal operations and legal tech. Enough from my side. I said enough for now. One last note, this panel is being recorded and later uploaded to YouTube. Now we will hear the opening statement from Mark Rotenberg on the difference between American and European regulation of AI. He will not be participating in the panel today, but we are very sure to pick up his insights during our discussion later on. So, dear tech team, if you could please. Wonderful, thank you very much.
Hello, my name is Mark Rotenberg. I am the founder and executive director of the Center for AI and Digital Policy. We are a global network of AI policy experts and advocates, and it is my pleasure today to be able to speak to you at the Recode Law Conference. I want to begin by congratulating you, the organizers, and the participants for taking on this important and timely topic. Artificial intelligence is transforming our lives, creating new challenges and also new opportunities. I believe the law has a central role to play in ensuring that we are able to maximize the benefits of artificial intelligence while minimizing the risks. Of course, I imagine you've heard others say similar things in the past. So maybe we should talk in a little bit more detail what it means precisely from a legal perspective to maximize benefits and minimize risks. First of all, I think it's important for us to be prepared to draw some lines, to make determinations that certain AI deployments simply should not be permitted. This was the view expressed by the former High Commissioner for Human Rights at the United Nations, Michelle Bachelet, who said several years ago that we should not allow AI systems that fail to comply with fundamental human rights. and I believe she was absolutely correct. I was also very pleased when this approach was carried forward in the UNESCO recommendation on AI ethics. The UNESCO recommendation states clearly that artificial intelligence should not be used for mass surveillance or social scoring, which is to say, assigning a number by governments to determine the level of patriotism of individuals in their private lives. That is a threat to open societies, to freedoms, and to pluralism that we all value. I was also pleased to see in the recent Artificial Intelligence Act of the European Union, which is now almost final, many prohibitions on AI deployments that should not be allowed, including the manipulation by subliminal messaging with AI system or for remote biometric identification. There are certain types of AI systems that we must recognize at the outset simply cannot be made ethical or responsible. They must be prohibited. But at the same time, I think we should also be prepared to explore the benefits of AI. We live in a world today facing enormous challenges, particularly with climate change and the growing disruption to our societies brought about by the human impacts on our environment. If we can use new AI systems in a responsible way to better assess and understand these processes and then come up with good solutions, I think that will be a form of progress to which some credit may be given to AI. But at the end of the day, it will ultimately be the decisions we make as people determining how AI is best to be used. And so, for example, I disagree with that common phrase that says, let's keep a human in the loop. I believe we must have a human in charge. And perhaps we can use an AI in the loop if it is helpful in our decision making. But it is not the AI that will be responsible for the decisions. It is the decisions that you and I make in the use of AI that will matter the most. So congratulations again on the organization of this wonderful conference. Please feel free to visit us online at the Center for AI and Digital Policy. And I hope that many of you will consider joining one of our AI policy clinics, where we are teaching young people like you the skills and advocacy techniques to become future leaders in the world of AI policy. Thank you again.
All right. Thank you, Mark, very much. I don't know if you are listening to this, but thanks very much for your insightful thoughts. Gabriela, if you want to continue with your opening statement, that would be wonderful.
Yes, thank you. So I'm going to share the screen so I can project slides. You tell me if you can see them.
Yes, wonderful. We can see them.
Can you see them in full screen, or is just
No, we see them in the edit mode.
What about now?
Now it's better.
Yes.
Cool. All right. So first of all, thank you for the invitation. It's a pleasure to be here with you. So I thought in the first introductory statements, of course, the topic today is about bias. But of course, bias is just one piece of a much bigger architecture in the AI Act. So I wanted to give you a bit of a framework to start with around the AI Act, and then dig a little bit deeper into how the AI Act deals with this concept of bias. This very quickly, this is probably something most of you are familiar with, is the risk-based approach of the AI Act, which we characterized with this pyramid, where we essentially say the objective is to show that the AI Act aims to regulate uses of AI systems differently depending on the type of risk they pose. So we start from a situation of unacceptable risk where essentially the law says certain type of uses should be prohibited, to situations of high risk, which, by the way, represent the greatest majority of the AI Act, is about, I would say, initially it was about, I would say, 95% of the provisions about high risk. Now we're probably going down to 80 or so, because we have some new additions during the trilogue. Then we have the third layer is about transparency risk. So we have situations in which the main issue is the fact that there's a lack of disclosure about the existence of the system, or for instance, about the existence of a certain type of content generated by AI. So when we talk about bias, in the context of the AI Act, we primarily focus on what is the high risk category. And so why? So the AI Act aims, so the objective of the AI Act is to ensure protection of health, safety, and fundamental rights by eliminating or reducing risk to those legally protected interests by way of establishing a number of requirements for high-risk AI systems and establishing a procedure whereby those systems needs to be verified for their conformity before they're placed on the market. What the AI Act doesn't do is to change anti-discrimination law. So that's very clear. The AI Act does not create new rights, does not create new, I would say, new fundamental rights in secondary legislation. So we already have, however, in the EU, a number of anti-discrimination law provisions. These are called the equality directives. So in that sense, the Act is complementary in the sense that it enables the proper enforcement of those anti-discrimination laws, but does not per se extend those discrimination laws, anti-discrimination laws. So that's why, for instance, ex-ante requirements aim to mitigate or reduce the risk that certain type of bias can be part of an operation of an AI system. Then we have also ex-post obligations, which also aim to correct in case certain type of discrimination may happen. And then we have a system of, in the context of the governance, to ensure that the enforcement authorities of anti-discrimination law also get access to the documentation and the information that is necessary to enforce anti-discrimination law, but information and documentation which is being created according to the new rules of the AI Act. So this is also another important element around the thinking behind the AI Act. This is a bit of a complex slide, but essentially, the AI Act does not enter into technical details. So the logic of the AI Act is to establish a number of legal requirements, and we'll see specifically about, for instance, the data. They are called typically in this type of legislation, which is, we call it new legislative framework legislation, essential requirements. So the requirements of the AI Act aim to determine the objectives to be achieved, but without entering into the details of the technical solutions that are needed to meet those objectives. So in that sense, it's an intentional choice to make sure, also for the purpose of ensuring a certain, let's say, future-proofness of the AI Act, in the sense that we want the technical solutions to be updated much more quickly than the law. And so by setting essentially the objective to be achieved, the law keeps a certain level of abstraction, but those technical solutions have to come primarily through standardization process, and we have indeed the European standardization system, but also can also come from other technical specifications, or generally from general engineering or scientific knowledge. The point being that manufacturers of AI system should have their technical solutions of choice to be able to comply with the law. However, indeed, in order to facilitate the process of demonstrating compliance, notably for those actors that are less equipped from a technological standpoint, the standardization, notably the European standardization, we call it harmonized standard, are in the making. So we are developing those standards in the context of the Sentinel Lake and ETSI, so that receive a mandate by the Commission to develop those standards. So, but it's important to really keep this in mind when you read the AI Act. Now, going specifically on the question about, let's say, bias, and primarily, so I checked actually yesterday. So the word bias, I can speak here only about the proposal. We don't have yet the final text, but the word bias is used 9 times in the proposal. The final text will be, I checked that too, is a little bit more, 23. But essentially, the concept of bias revolves around just a couple of provisions. And primarily, I would say the main one is on the data, the Article 10, which remains Article 10 in the final version, around data and data governance. The goal here is to establish an obligation for the provider of the AI system to establish appropriate data governance and management practices. Among those practices, there should also be an obligation to examine possible bias. We have also an obligation to ensure that the data sets that are used for the training of the models should be relevant, representative, with appropriate statistical properties, in particular as regards the persons on which their system is intended to be used. This article is also quite important because it contains a specific legal basis for the processing of personal data when their processing is necessary in order to ensuring bias monitoring, detection and monitoring, correction and monitoring. This is important because indeed, in order for certain bias also to be detected and possibly corrected, there is a need indeed to certainly process even special categories of personal data. These are related, for instance, to most sensitive categories of personal data. Let's put it that way. Now, here there's a little bit of maybe too much information on this slide, but I wanted to show how the abstract provisions of the AI Act need, in fact, to be materialized into much more concrete set of actions and provisions for the operators, for the providers. So, for instance, when you think, these are just examples, when we think a bit about data governance processes, so this should go into the specific, so let's take an example of an AI system used for admitting students to university. How do this data governance process could look like? So for instance, the data is collected by the university student management system software. There is a reference, must be a determination about how many data sets, how many data points. There must be a reference around, for instance, the fact that gender balanced, the data completeness, so where there are labels that are missing, some sort of pre-processing needs to be made. Again, when we think about relevant, there is the reference also to free of errors, by the way, in the AI Act, which has been highly contested. Representative, so what does it mean? So we want to make sure, for instance, that the data sets match the demographics of the students that are going to apply. We want to make sure that the data is up to date. So for instance, all the records are expunged from the data sets when, for instance, they sort of replicate historical biases, and then a number of sanity checks. But here, I wanted to show this example just to show you indeed that what you have to read into the provision of the Act is actually, you will not find that level of detail there. When you read the sentence, data set should be representative, relevant, or free of errors, basically there is an additional layer of actions that needs to be put in place by the providers that are not specifically or explicitly mentioned in the AI Act, but that indeed constitute the technical solutions by which the legal requirements should be met. So I'll stop it here and we can continue discussion later. Thank you.
We definitely will. Thank you very much, Gabriel. Yeah, Celine, you want to continue?
Yes, thank you.
Thank you.
Will share my slides. Are you able to see them?
Yes, thank you.
But not in presentation, right? So, like,
We're still in editing mode.
now?
Yes,
better.
yes.
Okay, thank you. Okay. Yeah, thank you for the opportunity to discuss this issue of if and how individuals are protected against biases in algorithms in Germany, as well as whether the AI Act offers enhanced protection, which is also, as mentioned, a primary focus of my PhD thesis. I broke the problems down into their key components, so I will not give specific information for all the topics, but give you an overview so we have enough time to discuss later. So the topics I aim to cover are as follows. First, I will provide you a comprehensive definition of bias, which forms the basis of my thesis and the basis of my research and understanding. Following that, I will examine the existing German anti-discrimination legislation and apply an example of algorithmic discrimination to illustrate its boundaries. Then I will briefly compare these regulations in Germany with the AI Act before reaching my conclusion. My research understands bias as the deviation of predictive outcome from the expected value. So the question I am to address is now whether the German law currently inactive and the draft AI Act effectively safeguard against algorithmic discrimination stemming from these kinds of biases. The example I chose is the Amazon recruiting tool. It was programmed with the task of screening job applications and trained with data from the past decade of recruitment decisions made by humans. And it then, however, began to exhibit a preference for male applicants and choosing only male applicants as their future employees. And so it caused, this preference was caused by biases present within the historical databases it had been trained on. So in the historical decisions or recruiting decisions, males were preferred out of the applications. As I said, I will use now this example to illustrate the boundaries of the existing German regulations. So first, I will provide you with a brief overview of the German Constitution and the General Act of Equal Treatment, known as the AGG. In Article 3, Sector 1 of the German Constitution, it states all persons shall be equal before the law. Article 3, Sector 2 condenses the protection to an equal treatment of the sexes, and a violation of this principle can only be justified by compelling biological reasons, so it's stricter. Finally, the Sector 3 prohibits differential treatment based on certain protected characteristics, such as gender, again, but also race, language, religion, etc. And apart from Sector 2, differential treatment may be justified by the principle of proportionality, so it's a little bit looser in the reasoning than the compelling biological reasons in Sector 2. When we apply this article to the example, we can see that the scope of Article 3 is not limited to human actions. So it includes discrimination by algorithmic decisions, but the protection against private action is only assumed, again, within the scope of indirect effects of fundamental rights. This means that the jurisdiction and legislation must not violate fundamental rights, but individuals can not invoke prohibition of discrimination. So therefore, the example of Amazon and the recruiting tool falls under the German law, but only if it would if the system would be implemented by the state itself and not by a private company. And the General Act on Equal Treatment, in short, AGG, formulates a protection against discrimination in employment. It establishes equal treatment of employees in section 7, based on protected characteristics, unless the differentiation can be justified by compelling reasons. So the scope is a little stricter. It's only the employment, but it falls under the private law discrimination. Then we have the section 19 of the AGG, which goes beyond the realm of employment, but only in the areas listed in section 2. And unequal treatment can be justified by objective reasons, so it's not as strictly as by compelling reasons. Applied to the example, the AGG includes private legal relationships within its scope, and the Amazon tool, of course, because of the employment and the recruiting procedure, falls under the rules of the AGG. But the scope beyond employment is restricted only to bulk business and private law insurances. This is just kept it short. It's much more complicated than that, but in the basic, it's just bulk business and private law insurances. So the protection beyond employment is very small and restricted. So to conclude, just the German law, the German constitution provides sector unspecific protection against the use of algorithmic systems by the state, whereas the AGG offers sector-specific protection against the use of algorithmic systems in private parties. So we do not have a regulation protecting in sector unspecific situations and against discrimination by state and private companies. So now I would just like to use the remaining minutes for the AI Act. As mentioned already, the AI Act follows a risk-based approach, which subjects AI systems to different regulations, depending on the risks they pose on health and safety of individuals. Thus, the use of AI systems engaging in practices prohibited under Article 5 are forbidden, and AI systems posing high risks are subject to conformity assessment procedures. And also, I think included by the last drafting, there is also a fundamental rights impact assessment for high-risk AI systems which provide public services. But although the AI Act provides a better basis for regulating AI systems than the German law does, the following points are not addressed fully. So the list of prohibited AI practices is not expandable per se. It is not that exclusive, but it's not very easy to include new AI systems. And as we know, the technical, the AI systems will develop further, and the law may not follow up. Moreover, the conformity assessment procedures are not conducted by independent third parties, but rather by the providers of the AI systems themselves. They are overviewed, but not in a, not strictly enough. And then due to the significant impact that discriminatory algorithms can have on fundamental rights, in my opinion, fundamental rights assessments should also be conducted by independent third parties in cases of private use of AI systems, and not just when they serve public services. So to conclude, in neither the existing national law in Germany nor the EU's AI Act is capable of comprehensively addressing and minimizing discrimination by AI systems in a whole and in all sectors. Because just to, again, summarize, the German constitution protects against discrimination in all sectors, but only guards against state actions. The AGG, on the other hand, offers protection in private law, but only sector-specific. And the AI Act places the burden of ensuring non-discriminatory application on the provider itself, without implementing a fundamental rights assessment in private law contexts or assessing the self-assessment by third-party control. Thank you very much.
Thank you. Alyosha, you would be last, but definitely not least.
Yeah, let's see. Thank you so much.
Sure.
Oh, I forgot to clap my hands for Celine, so please let's do that. Yeah, let me try to evoke some sympathy or maybe empathy for the machines, maybe sympathy for the machines. First things first, bias is something completely normal. We are humans, we have hundreds of biases and we are using them all the time. Bias helps us to cope with the complexity of life. We always don't have the possibility to think through all our decisions to the very end. We don't have all the information at hand. We have limited time, limited capacities. So many decisions we have to base on our gut feelings, on rules of thumbs, on heuristics, right? This is completely normal. If you've read Kahneman, Thinking Fast and Slow, there are dozens of examples. I mean, one that stick to my mind, where also our engine can easily be tricked, if you wish, the working of our brain. If you take a glass of marble and put it on a table and ask people to assess how many marbles are in this glass, then people on average will come up with some number that meets the truth, like 250, say, right? But then if you pose the question in a different way, if you ask the people, are there less than 10 marbles in this glass or more than 10 marbles? Or if you say, are there less than 1 million marbles in this glass or more than 1 million marbles? Then by mentioning 10 or 1 million, I mean, which are absurd numbers, then the people's assessment changes. Yeah? They think there are more marbles in there, or they say there are less marbles in there because this number is in the room. Yeah, this number influences the way how we assess the number of marbles in this glass. So bias is something completely natural, but what must not happen is that discrimination occurs due to bias. I mean, that this leads to an unjustful treatment of other humans, right? So that's it's asked for my language, so flip. That's what must not happen. And if you think how difficult this is even for us humans, I always think of the following situation, but you are law people, I mean, tell me if I'm right. When I think you are the border police, yeah, you have to check people coming from Amsterdam to Germany on the train, and you have to check for cannabis smuggling, right? And then you enter a train compartment, and there are 2 old ladies sitting, and there are 2 young boys, or young people sitting. I mean, who would the border police check for cannabis? I mean, in principle, they are not allowed to discriminate people by age or by sex and think that the young males are more probable to have cannabis with them than the old ladies. So in principle, they should flip a coin and then decide who to check. But they have limited time, yeah, and they want to find the drugs. So I think they are in an internal conflict. But if I'm not mistaken, they are not allowed to take these discriminatory measures and think that some people, due to their age or sex, are more likely to have in their pockets what they are looking for. And this brings me now to the system. So if you now take a camera, put a camera on these policemen's head and film these scrutiny situations, and then the system should later decide on its own which people to check for drugs, then you know what would come out. I mean, the system would, of course, be discriminative. Yeah, there would probably racism, there would be probably sexism and other prejudices be found in the system trained on real world data, as my previous speakers have said, because the world is the way it is. And in this way, you can first of all say that the systems, they are a mirror to us, and they show what kind of discrimination and racism is in the world. But anyway, it's our task to make them better. Yeah, that's not what we can be happy about and where we can lean back and say that's the way it is. When we talk about systems and biases, then people have made it very detailed lists of where the sources for bias. Bias is not one single problem, but I mean, it's the sources of errors that can lead to bias. I mean, we've discussed about data bias, that the proportion of, say, different genders in the training data was not right. Yeah, for example, when you train a machine translation system, then it's most likely, as of today, that it will translate the English lawyer into Anwalt, into the male German form, much more often than into Anwältin in the female German form, because it has seen it more often. Also because, I mean, Anwalt is also the kind of neutral form, at least in standard German as of today. Yeah, so that it's being changed, but that would be the most likely translation. And for cashier or for nurse, also you would find the opposite problem, right? And then so there is problem in the data, and this leads then to problem in the models. But the problem in the models can also come because it derives wrong heuristics or wrong shortcuts. Yeah, I've always seen this and that together. I mean, that was purely accidental, and I've taken it for one for a reason for the other, right? I mean, these are because, I mean, systems are not good in finding true reasons. They don't have reasoning engines, but they find correlations. Yeah, that things correlates. I mean, there are certain birds, and there are certain rural areas, and there is a high rate of cancer. Then they think that rural area is the reason that many people get cancer, but it's only because there are few people living in rural areas. And when in a village with 5 people, one has cancer, then 20% of the population has cancer. Right, and this leads to wrong correlations, and we humans know these cases. So there is problems in the models that they don't get the right information, and it's not so easy to tell the people, but to tell the systems what are the right features and what is wrong, because often enough we cannot look into the details of the systems as good as we would want to, and even if we try to delete features from the training data. You mentioned the human resource management tool at Amazon. Even if we say we would delete the sex or gender feature from the applicants, of course, the first name would give indication whether they are male or female. Maternity leave today still gives a good hint as to whether people are male or female, right? Because typically the women have longer maternity breaks, and certain high schools and so on will stand for male or women, or certain hobbies and activities that the people mention. And even more complicated if you want to delete the age. If you want to delete the date of birth, then you have to delete the time they graduated. Then you have to, I don't know, the number of internships also tells you whether people are young or older and so on. There are many proxy items for certain things that it's not so easy to say, oh, let's clean off the age and gender from the data, and then we have it. And there are other types of bias. For example, my colleague always says there's also this human-computer interface bias, that the interface may lead people to certain conclusions that are invalid. But they don't understand the training system, they don't understand the interface, they don't understand what the systems do, because it's misleading and it doesn't show its boundaries, for example, right? I mean, systems might not have been engineered for certain use cases, but we don't see it when we operate them. Yeah, it just looks right. There is something, yeah, a result, yeah, of the system, but I misinterpreted, and this leads to discrimination, because I didn't see that the system was not fit, for example, processing this type of person. Yeah, it just didn't know, and I don't know. Yeah, maybe there is this example of the foam or soap spending system that has a sensor in it that wouldn't work for black people's hands, right? Yeah, because they have a different color of skin, and they don't work for these sensors. But the soap spender doesn't tell me. Yeah, it looks like a soap spender that works for all people, right? And I simply had no choice and no chance to understand that was not made for me, maybe, and that it doesn't work for me. So that's also bad engineering at that point, and this should be circumvented. So there are many facets of bias in the system. There's not one problem and one solution. And if we come to my last section, if you wish, mitigations, what can we do about it? I said it's not that we see it. It's not the starting point. It's not the end. It's the starting point. First of all, I think we have to stick our heads together, what we are doing here now, in an interdisciplinary way, and discuss what is the normative basis of the system that we want to have, or what are our normative demands. Like if I'm coming back to the machine translation system that translates lawyer into male Anwalt or female Anwältin, when would I be happy? If it translates, uses the male form in 50% of the cases, or 60%, or 60-40, 70-30, 80-20, what would be the normative boundary within which I would say now the system is good? And I mean, when it's more, and that was interesting in what you said, Gabrielle, if it matches the demographic of the applicants, for example, at Amazon, when 80% male people apply to the system, then maybe the system, the way it was, is okay, because they have a good chance of getting through. Yeah, it's only a problem for these 20% women. They have a problem. Yeah, well, so that was an interesting thing we could discuss about. Yeah, matching the demographics of in the real world, in the discriminative real world, or in an ideal world that we could think could be much better than the real world, right? When there are only 10% female applicants for engineering studies at universities, is that what we want to go with? Yeah, so the university application system is good when it maintains this, or do we want to do better or differently in this respect? So we have to find the normative basis, and there's a lot of discussion and negotiation, I think, that needs to happen. And then we have to think about more technical solutions. Do we need first I wanted to say a human in the loop, but from Mark, I've learned I'm supposed to say a human in charge. Of course, systems never take decisions. System can operationalize decisions. I'm completely with him. Humans take decisions. Systems can put them into operation, right? Do we have to build synthetic data, for example, if we have too few applicants of certain type? Yeah, can we build synthetic data so that our training data is a little bit better in terms of proportion? Can we build hybrid systems? So we have one part of the system that makes these fast thinking kind of mistakes like we human, but then we have a second system that says, stop, wait. Yeah, so intuitively, you've chosen for the one with the first name Alexander, not for the one with the first name Alyosha. Yeah, that was discriminating against people with Eastern European first names, right? But then there is my rational system that says, stop, I didn't want to choose applicants on this basis, let's do better, right? Can we maybe build hybrid systems that are made of a learning component and maybe a normative, scripted direct component? And yeah, and maybe that's that for from my side for the moment. And also, Selin, what you said, this equal treatment, for example. Let me finish with that. You talked about equal treatment. Yeah, say if a company has a policies so that when people have the same fitness for a job description, so we want to invite the woman for the interview because we have too few women in our company. That's a normal thing to do, right? I mean, we do it in Germany, for example. But what is the same fitness for a certain job? It's not exactly the same school grade or the number of internships. Yeah, so how can I measure when two people have exactly the same fitness, right? For humans, it's, I guess, rather a gut feeling. Yeah, so we have the two applicants, and then we are they the same? Then I should take the woman, and if not, I can take the man. But if we want to operationalize that and put it into a system, then we maybe at some point we have to be much clearer in what we mean by certain terms or certain things that we as humans we are doing, yeah, just the way we've done them all the time, yeah, with a mixture of gut feeling, experience, rules of thumbs, ask my older colleague, and whatever you can do. But this is also a chance that could lead to more transparency and to better processes and more algorithmic and clearer processes of when do I consider two people to be in the same range. And as you said, in public positions, people can then use the law and can say, I wasn't invited to a job interview, but they gave it to somebody else, like a professorship, right, which is a public position. But then only in retrospect, then experts will go and when we'll discuss, were they two people really of the same fitness for the job? And then it will be discussed in retrospect. But beforehand, we wouldn't have all the criteria for this job in a very clear format. And so I also see the chance to put it positive, that this digital mirror also gives us a chance to get some processes right and to help to shape a better and more bias-free and justice future. Thank you.
Thank you very much, Alyosha, and thanks to all of you for your insightful keynote speeches. Yeah, to kick off the discussion, maybe we should first just define a few basics about bias in AI systems so that we are all on the same page here. I actually just read this morning that after the EU member states approved the AI Act 2 weeks ago, just yesterday morning, the leading committees approved the trilogue negotiations with a huge majority of 71 to 8, with just 7 abstentions as well. Again, to kick off the discussion, I bet everybody's eager to know, Gabriel, where do we stand with the AI Act, and what are the next steps? What are we looking forward to?
Yes, so indeed, as you said, just taking a step back, just for everyone to know, so the trilogues, which is this form of dialogues between three parties, essentially, terminated in December last year, on the 8th of December. That was the last meeting between the political levels of the Commission, the Council, and the Parliament. Because typically EU legislation, so in this case we have what we call an ordinary legislative procedure, which means that the Commission makes the proposal. I mean, the Commission role is always that. The Commission doesn't decide. The Commission makes the proposal, and then the proposal goes to 2 chambers, essentially. So the European Parliament is one chamber and the Council is another chamber. The European Parliament represents the member states, the people, because they are directly elected, and the Council represents the member states. And they have to agree on the same text. And in the last, let's say, couple of decades, there has been this practice indeed of developing an informal way of coming to an agreement through these trilogues. Therefore, typically, once the 2 institutions, so the Parliament and the Council, have their own position, they have developed their own thinking about the Commission proposal, they engage into these dialogues. And once the negotiation teams have come to an agreement, then the text goes back to their constituency. So to the Council on one hand and to the Parliament on the other hand. And each institution has several layers, because as you correctly said, Ramona, 2 weeks ago there was an approval of the text that was agreed by basically the negotiation team in December, with some further technical work done through January, was endorsed by the COREPER, which is Comité des Représentants Permanents, so at the ambassador level of the Council. And yesterday, or the day before yesterday, there was an approval by the committee, the parliamentary committees responsible for the AI Act, which were the Libe Committee, so Civil Liberties Committee, and the IMCO, which is the Internal Market. Now, the next step is the first reading by the European Parliament, which is supposed to happen in April. And but the European Parliament is voting basically the same text that the member states at COREPER level have already endorsed. So it's not a different text. So, and once the Parliament, if the Parliament decides to approve that text, they already have basically the confirmation that the Council on the other side will give a positive vote at the Council level, which means at the minister level. So that's when the decisions are finalized. So that's where we are. And if all goes well as planned, indeed, after the Parliament vote in April, we may have the final text published relatively soon afterwards.
Thank you very much. Good kickoff to the discussion later on. Maybe one more definition so that we're all on the same page. Alyosha, we've already heard some definitions of bias and also examples. Thanks again for that. That was really helpful. but maybe could you maybe enlighten us on how you understand bias technically and maybe also ethically, but maybe technically, how do they actually origin?
I would say it's the deviation from the, and if we put it in this wider reading, from the ideal result that you would come up with in an ideal world, I mean, with ideal information, and when you knew everything about the situation, then you would come up with a decision that it's, I mean, doing justice to everyone, that it's legal, that is perfect, if you wish. I mean, that would be the normative basis that we have to define, yeah, and this is what, and the bias is then a deviation from it, yeah. So I take a decision that is less than this normative ideal decision, and then the question is, from when on, I would say it's critically off it, as we had in this discussion with the translation system. So 50-50, if we decide now it's a normative rule at the translation system, every second time needs to take the male form of lawyer in the German translation, every other time the female, now irrespective of whether the text gives other hints about the gender of the acting people. But let's say that would be our normative, then we would have to discuss, I mean, when there are 50,000 male ones and 49,999 female mentions, whether that's still okay or whether that's already a bias that we want to work against, right? I think it's that thing. And we must not confuse it. I mean, people are talking about technical fairness measures. I mean, these fairness measures are around. They are used in computer science to optimize models during training or so, but they can only, let's put it this way, they can only talk about what they've seen. Yeah, when there are green balls and blue balls in the training data, then they can see whether there are the same number of green balls and blue balls. But if we would wish that there were red balls, but they were not there during training, then the system will not ask, oh, I have one question, are there red balls in the world that you forgot, yeah, that you overlooked? Of course, yeah, the system has no conclusion. So these fairness measures in a narrower sense, they can only work with what they have. But what is important for us is to have this, to see bias as a deviation from a normative idea. And it can be by humans or by machines, right?
Good point, thanks. And I mean, at the end, it's always a question on, how you understand bias. And you can understand them obviously in different ways, right? I mean, depending on understandings in various cultures, countries, regarding ethics, fairness, like you mentioned, and bias can also then lead to wrong predictions and classifications. But yeah, maybe on this topic, we'll pick up this topic later on.
But still, sorry if I interrupt you, but still make the difference. I mean, bias is one thing, and discrimination and racism and so on is another thing, right? Bias must by no means lead to discrimination. So we will never get rid of bias. Bias will always be there. We can minimize it, but it will always be there. But I mean, what we really have to work on it, that doesn't lead to, I mean, injustice or disadvantages of any protected. And that's now one thing I forgot, not only protected groups. We know which we have to look for: gender, age, sex, ethnicity, and so on. But the systems may discriminate against new groups that we didn't have on our list of protected groups by human bias. Yeah, they might discriminate against people with a capital R in their last name, but we didn't check for it. Yeah, that's not a part of AGG or so, but still it's a problem, right? I mean, this is something we should also keep in mind. But I stop here.
Thank you. Well, I'll pick that up later in our third part. Just moving over to our second part of the discussion, we'll take a closer look at the EU AI Act and adding to Selene's opening statement, let's take a closer look at whether the EU AI Act is protecting individuals and groups enough from bias and algorithms. The recently published AI Act does not provide for a far-reaching ban on remote biometric identification or emotion recognition as originally intended by the EU Parliament. Maybe real quick on a definition, remote biometric identification refers to the identification of individuals based on specific physical or physically manifesting characteristics without physical proximity. Such systems make it possible to identify individuals by analyzing data from various technical recordings that are compared with existing data. The most common example here is moving images from surveillance cameras, which are used for facial recognition, but that's only one example. So as far as I understand it, remote biometric identification is not prohibited for law enforcement purposes in public spaces. That's Article 5, Section 2. While there are clear benefits for deterring and prosecuting crime, of course, even the most effective methods must be assessed on the basis of relevant legal principles and human rights. So also with regard to this example, is the EU protecting individuals and groups enough from bias in algorithms? And could you please elaborate maybe a bit on what you said in your keynote speech, especially your last slide?
Yeah, sure. I think, like I said in my opening statement, no, I do not think that we are, or individuals and groups are not protected well enough against discrimination. I agree with that we do need to differentiate between bias and discrimination. And the likely cause of biases are discriminated or discriminating decisions by AI. And so I'm not sure if I'm answering your question on the point, but I think that we do not need just a self-assessment. So right now we are, and Gabrielle can, of course, correct me if I'm wrong, but as I understand the AI Act, the self-assessment is the main tool to minimize biases and discrimination because of biases. And it is in a very small area overviewed and in the ex post monitoring process, but it is a ex ante tool. We look at the AI Act at the beginning before it is put into service and used, and we look if the AI system is producing biases when it started to be used. And as we know, machine systems can develop, or not just can, but they do develop. They change their habits. Habit is like just a human kind of definition, but they change their models on how they come to a conclusion, come to an answer to a question input, and they change their outputs. And so I think the ex ante risk assessment done by or required by the providers of the systems themselves are not enough to, first of all, protect against new biases which may occur after putting them into service. And self-assessment is like putting, we have the TÜV here in Germany, like so if I would just state that I could, if we did not have the TÜV, which is a third-party assessment procedure for example, checking if my car is fit enough for the traffic. And if we did not have the third-party assessment, I could just put a label on my car and say, yeah, it is fit for traffic and I can use it as I want. And this is kind of what we do with AI systems, in my opinion. We just say the providers themselves can put this label on their AI system and say, yeah, we are conform with the AI Act and with the provisions of the AI Act. And you can use them. You can be sure that the individuals can be sure, I will not be discriminated against. and the an individual who has not the knowledge we do right now discuss about, it will just rely to this assessment and this certificate, and will just say, okay, the decision if Amazon decides to not employ me because I'm a woman, it will just say, okay, it's neutral because an AI system does not have biases like prejudice against females. Or, I mean, okay, in a kind of employment situation, we have, of course, biased decisions by humans too, but we have also the example for like the fitness studio in America. I don't know where it was, but there was a woman couldn't go into the ladies, I'm just not knowing the name right now, but in the dressing room for women because she had a doctor title, and the AI system just said that, or just learned that doctor titles are just male. So of course we have situations where humans can make biased decisions also, but we as humans would not say that doctor titles can only be male titles. And so I think that we need to address the bigger issues that the AI systems, or the biases the AI systems can provoke, are much bigger than by human decisions. So I think we cannot just rely on a self-assessment and the provider themselves say, okay, my AI system is okay and can be used, but we have to give them a third-party assessment also, and monitoring of third-party also.
Thank you. That actually did answer my question, to answer your question. Thank you. So we've learned that companies will have to comply with a lot of new regulations. Gabriel, you said in your answer to our question prior to the conference that one of the goals of the AI Act is to ensure that AI systems available on the EU market are safe and compliant. So which institutions will monitor and ensure this compliance, and maybe what are some of their tasks? Could you please maybe name a few?
Sorry, what was the last bit of your question?
Oh, just name their tasks, and if there are like new entities being created, or like old ones that are surveying the compliance. Yes.
Okay. Yes. So in terms of just also reflecting a little bit of what Selene just said, the system foresees an ex ante and ex post type of verification. So first of all, of course, as it happens with any, I would say, products that are put on the market, including products that, of course, impact even our life. Think, for instance, about medical devices, or think of cars or airplanes. What the legislation can do is, of course, tackle, address, eliminate, and mitigate risks as much as possible. But I mean, in certain situations, there could be, it's hard to have a mathematical certainty or 100% certainty that nothing can go wrong. And that's why the EU has a tendency towards, certainly compared to other legal systems, let's think, for instance, about American legal system, where, you know, the ex post, it's much stronger in the sense that compliance is more instigated through ex post as opposed to necessarily through ex ante regulatory costs. We in Europe tend to have, let's say, a more prominent ex ante framework as opposed to an ex post framework. And but in any case, as with any ex-ante framework, you never get 100% certainty. So the goal is to certainly eliminate as much as possible risk you can identify and mitigate those you cannot identify, and even inform. Ultimately, if there are risks you cannot even mitigate, you just have to inform the users. So that is why we have this ex-ante, which is indeed, if we look at the examples of product legislation, you don't always have third-party conformity assessment. So there are third-party conformity assessment in certain cases, but not in all of them. For instance, if you take the medical device regulation, not all medical devices are subject to third-party conformity assessment. Some are subject to some sort of voluntary, it's not voluntary, it's a mistake, but some sort of self-assessment. So the compliance, so the law is the same. The obligation of the provider to comply with the law is the same regardless of the procedure by which you demonstrate compliance. So if you can go to TÜV, for instance, so it's a third-party certification system, but note that the TÜV doesn't take necessarily the responsibility. The CE mark has to be put by the provider. It's the provider who undergoes the third-party conformity assessment, gets a certificate, but it's still the responsibility of the provider to put the CE mark. And so the obligation is the same, but it's true that the AI Act for certain type of systems, notably those in Annex 3, although not all of them, because for instance, biometric systems are subject to third-party conformity assessment, it's foreseen as self-assessment. With a caveat, this was in our proposal, I believe it's still in there. I'm still finding my own way into the final text. So the Commission can trigger the third-party conformity assessment also in cases when there is currently a self-assessment. So if in the future the Commission identifies that there are shortcomings in the self-assessment systems, it could be possible to say, okay, now we need to shift certain use cases to the third-party conformity assessment. But so what I wanted to say is that certainly the self-assessment is one layer of enforcement ex ante, but then indeed, as you said, Ramona, we also have essentially authorities that are responsible for ensuring compliance of the system that are already in the EU market after they've been basically placed on the market by the developers. And here they are the market surveillance authorities. They are responsible for ensuring compliance. In case, for instance, there are accidents or even complaints by producers or by consumers, they have all the tools to essentially check those systems, test them, even they have quite extensive powers. These are regulated in the market surveillance regulation. So they can also reverse engineer products. And indeed, the system foresees the possibility that even when products are already in the market, they can be checked. And if needed, there may be need to correct them or even withdraw them. So there is also the possibility for market surveillance authorities to take them out of the market, to find the operators. And this is so this has to be seen together. Again, perhaps it's not a guarantee for 100% no faults, but certainly here, and this has been also an important consideration that we as Commission also wanted to highlight since the beginning. I think we should be careful not to demand from machines what even humans are not able to do. So in a way, we should find a balance there. Certainly, as also Alyosha said before, I mean, certainly that doesn't mean we should sort of stick to what the bias that humans have. We certainly have to take that in consideration and improve that, especially to the extent we delegate to the machines very sensitive decision making. But we should not forget that indeed this is certainly quite a complex area, and the law cannot also become a sort of a roadblock or a bottleneck to the use of certain beneficial use of these technologies.
Thank you. Celine, you raised your hand first.
Yeah, thank you. Yeah, I am I share your opinion that we do have a multiple tools to correct the ex-ante assessment, which is done by the provider itself. But don't you think that as of course we will not have 100% neutral AI systems, as we do not have 100% neutral humans and will never have. But other than human decisions, we are more or less, we do know that we have biased decisions or biased opinions. But don't you think that by replicating the data based on our human decisions, we will multiply, or we already do multiply, the biases caused by human decisions, but also by not representative databases, such as when you Google a wedding dress, you only get Western white wedding dresses and not of other cultures. Or when you Facebook has the horrific example of underlining a group photo of Black people as gorillas. And so don't we multiply and in a never-ending factor the already existing biases? So I just think that beside the already implemented assessment methods in the AI Act, we do need a more focused look on the fundamental rights and the sensible characteristics such as race, ethical inheritance, gender, sex, etc.
Oh, Yasha, do you want to directly add on to that, or was another question?
No, I can. I mean, yes, I mean, this has been studied under the heading of, I'm sorry for my family invasion, I was wandering around this house a little bit. This was studied under filter bubbles, confirmation bias, and these kinds of, I think that is proven what you say, that this, of course, fortifies and extends biases in an unnecessary way. But sometimes I'm a little bit sarcastic at this point, and I say, I mean, for those people who read Boulevard News in the morning and watch private television at night and go to church on Sundays, they might also be living in a certain kind of bubble. It's hard to get out. Yeah, I mean, so that, but still, this is a technical means that can scale. Yeah, and we see it. I mean, we see it at this point in Germany. There's political campaigns running on TikTok and so on, and it's really not good. Yeah, and it's really, I mean, taking people by their human sides, right, and then yeah, I mean, radicalizes them and anti-democratizes them. That's not good. I mean, but maybe the tools can also be the solutions. Nobody says that social media must be anti-democratic, or that information and knowledge tools must lead to disinformation. Yeah, I think so. I'm still maybe optimistic by trade that we can turn it to a better, yeah, to a human and public wealth oriented kind of technology. But this means that we all have to engage, and that we all have to design, and that we all have to question, and that we all have to bring our don't leave it to the bad people, yeah, to develop the technologies and bring it to our kids, yeah, if I put it this way. But I was raising my hand for one quick afterthought on mass surveillance, on the question to Selin a while ago. I mean, there was this experiment in Berlin at Südkreuz, at this public train stations, where they put cameras to trace terrorists, right, basically, right? And they would then survey people, and then the camera, the AI-based camera, would say, yeah, this is a potential terrorist, and so on. And then people are checked, and then people are so. And then journalists said, oh my God, yeah, every day so and so many thousand innocent people, they are potential terrorists, and this is, I mean, doing injustice to people. And everybody was angry about it, which I understand. But few people ask, how many terrorists can pass by the camera without being identified as terrorists. I mean, the other error, right? There are different errors that the systems made. Yeah, they make alpha and beta errors and so on. And we have to, when we discuss about the pros and cons on these systems, then we should discuss both, right? I mean, and if the system is very good and each and every terrorist is being caught, then we can talk about whether it's okay that the police checks a few innocent people or not. But if the system not even works for the other thing, I mean, then we have even more reason not to do it. I mean, now we decided on the EU level that that is just an example, yeah, that we don't want to do mass surveillance, but at all. I guess only maybe for these reasons we do. And in retrospect, I don't know. But you tell me what's the current reading. But what my point only was, we have to have a differentiated view on what was the goal of the system, what are direct effects and what are side effects on the system, and then we put them all in a SWOT analysis, and then we discuss whether we still want it or whether the positive effects outweigh, or whether the negative effects outweigh the positive effect, but make a holistic assessment of the thing.
Maybe quick thoughts on that, because we have some more questions, and maybe for everybody listening, we started a bit later, so we will continue for some more minutes. Now already, yeah, do see the time, but yeah, Celine, if you quickly want to add onto that.
Yeah, I just wanted to add another example to the mass surveillance. I do not think that just because we have worse situations and we, in the mass surveillance situation, we want, of course, to find the terrorist that could escape this surveillance. I think that we do not, that does not make the biased things less bad. So I think that we have already failed in our human decisions. And I just wanted to add an example in the medicine. So all the medicine researchers are right now, it continues. It's not historic information. We continue to research medicine just on the male body, and this is our human decision we are making right now, and we continue to make. And I do think that we have failed in our to assess our human decisions, and so I think this will duplicate and multiply when we start to use, or we do already use, but we start to use AI systems more often, and we will continue to just think that females are just a little bit shorter males and we can research medicine only on the male body, or airbags in the cars just on the male body. And I do think that we have to put a cut to this and just not say, so this is just my reaction to Alyosha, because we should not say, okay, we have worse situations, so our biased decision in question is not that really bad, because we have better situations at hand. Thank you.
One sense, no, I fully agree with you. And this holds for all kinds of digitalization projects. A good process critique of what we are doing now and what we want to have is the best starting point for all these projects. I mean, if we just put, bad analog, you've heard it 1,000 times. If you're putting a bad analog process in the digital process, then it's a bad digital process. It doesn't get better during this transformation. Of course, I fully agree. And the better is not the only enemy of the worse. And I fully agree.
That is actually a very good transition to my next question, to the topic AI safety standards. Like Mark Rotenberg said in his opening statement, we need to establish red lines for the development and the implementation of AI systems. And one solution, or one thing we could think about and discuss is for those AI safety standards, the so-called trustworthy AI. Is that really help, or what exactly is that? Alyosha, if you could elaborate on that, please.
I mean, I would point it this way, that trustworthy AI is in a way is more a kind of, yeah, what would I say, thinking. Yeah, you start from very general human rights principles, yeah, the human dignity and so on, and then break this down into questions that you can ask systems or in system development, right? So I think it's a procedure. It's a procedure, and I think this can really force us to think about to think about what are the factors that we want to take into consideration in system design, and as I said, to discuss these normative standards that we want to adhere to. So I think this trustworthy AI that has been suggested by the high-level group of the EU, starting, I mean, with, as I said, general principles that no discrimination, don't hurt anybody, yeah, so respect the human dignity and so on. They are very general. They could apply to all kinds of services and all kinds of tools in the world. They are not AI specific. But what is the really important task is go from there. Then it gets one level more concrete in these like pre-structured questionnaires. Yeah, so then are the people trained for the systems they are working on? Is it transparent? Is it robust? I mean, these are things we've discussed at various places here. I mean, which is still very abstract. Is it robust? Are people trained? I mean, and then you have to break it down into the real good question. What does it mean for a medical device to be robust? What does it mean for a surveillance camera to be robust? What does it mean for a chatbot to be robust and to be transparent, and that the people are well trained for the systems? And so I think it's a way of critical thinking that can lead us from very abstract principles that we can all adhere to, that we can all subscribe to, because I mean, these are basic principles of human rights that everybody in the world, hopefully, in the good people share. Then we can these break down into system developments. But at the same time, and this also, I mean, Gabrielle probably knows it. I mean, we must not fall into the trap of overstretching AI for regulating many things that have to do with social media, with internet usage. I mean, young people getting stupid because they stop reading, and there are so many computers in the world, and social media makes people aggressive and so on. I mean, we cannot blame everything that we don't like about this world on AI, energy usage, and this and that. I think we have to be a little bit fair when we do this breakdown, and then really ask ourselves: is there a regulatory gap? That's what we are talking about. Is there a real gap? I mean, stealing was illegal before AI. Stealing is illegal after AI. Plagiarism was illegal before AI. Plagiarism is still illegal after AI. But is the fact that through AI we can so easily now copy images or create new images in the style of somebody, or make music in the style of a known artist or so, does this add a new regulatory gap that we really need to fill? And so this is, for me, a really long, this is a long answer and a really long way from general principles into critical questions, whatever I find in the smallest detail. And this is important for me, and then I stop. Yeah, but does it really talk about AI? Does it still really have to do with AI, or is that something that I wanted to regulate anyway for a long time on social media because I don't like it? But then I should use a different means. Then I should use the DSA or other legal frameworks that are in place for these things.
Thank you. Maybe, Celine, real quick, we've heard that you just published an article on gender-neutral AI. Could you maybe explain the difference, or what exactly that is, what the concept behind that is?
Gender-neutral AI is, of course, a kind of what we would like to have in a perfect world, but we try to first of all look into the kinds of thinking already done about non-discriminatory AI, and just try to for example, the I don't know right now, we had the feasibility study and other kinds of EU paper on regulating trustworthy or being able to regulate trustworthy AI or produce trustworthy AI. And after that, we just tried to give the companies tools to which they could use, or tools, thinkings and points which they can use to just before the AI Act is in practice, they could use to implement in their systems to be more trustworthy, to be more not just gender neutral, but against discrimination or discrimination neutral in general. And we do not have, after 150 pages, I think we do not have a solution, but we just tried to give, as I said, tools for non-technical and non-juris law people, different tools at hand to provide a kind of guide for them, what they can, how they can change the AI systems they already use, or for which kind of bias they should, which kind of bias they should change or minimize. If that answers your question. But I just wanted to add a quick thing to the first question you posed to Ayosha, because I do think that just trustworthy AI is just AI that, to put it very simple, offers transparency, so that I, who uses a chatbot or uses a different kind of AI system, know what the AI system is doing, and have also, beside of transparency, have subject rights, so that I can, if I want to, have information, get information, and if I do feel like I am misguided or mistreated in any kind of way, I can give my reaction to it, so the AI system can be changed, and I can have my any kind of rights. And again, the English word doesn't come to mind, but just a second. My harms can be my if I have any discriminating results harming me, that I need to have kind of Schadensersatz is what I mean. Thank you.
Thank you. It depends on, I think you can just say damages, but I think, we got your point. Maybe before coming to our last question for the whole panel, we've already received one question in the chat. Again, the invitation for everybody to please post questions right now. But yeah, I'll pick the first question. It's to Gabrielle. Do you think that the AI Act will have a strong educative role for the industry and means of developing suitable rules of conduct? Or will the industry search and find for smart solutions in order to bypass EU regulation?
Yes, thank you for the question. I mean, the AI Act is a binding legal framework. So I would not, although the law can somehow also have some sort of educative function, but to me, the law is a tool where certain rules, so there is sort of a normative basis that then is agreed, and then it's a matter of complying it. So it also can contribute to educational change, but I see the law per se, or at least the AI Act per se, not from fulfilling that primary role, because indeed the way to shape societal change can happen in many other different ways, through indeed other forms of disseminating information, educating people through other form of policy actions that are not necessarily binding law, that mean like a product legislation, like is the AI Act, where there is an obligation for providers to meet certain requirements, and if they don't do that, there can be sanctions, their product can be withdrawn from the market. So certainly, generally speaking, I mean, this type of law can contribute to societal change and education in society, but in my view, the primary function of the law is a bit different. And I would certainly indeed not exclude that other accompanying measures can support a more educational function in society, like for instance supporting programs to support awareness about use of AI literacy, for instance, or how to make sure that workforce needs to be diverse in order to develop AI systems that indeed also respect a plurality of values. So these are type of actions that, in my view, are more suited for a non-binding type of approach. And in brackets, also the Act includes one section about voluntary code of conduct, where it's possible for operators, providers, among others, to develop code of conducts where, without being obliged to do anything by the law, but they commit to meeting certain requirements which may also go beyond or separate than requirements that are specific for high-risk AI systems, like for instance in relation to the environmental impact, or in relation indeed to the diversity of the workforce, something like that.
Or trustworthy AI.
Yeah, there's something, and indeed going back a bit to your point, Alyosha, when we developed the AI Act, of course, we relied extensively on the work of a high-level expert group. But we realized that one thing is to write ethical guidelines by an expert group. One thing is to write a law. And we needed to make a choice. Also because, as you also pointed out before and correctly said, the AI Act is not going to be the panacea of solving all the world's problem. It's not meant to be that way. And it's one piece of the puzzle of an legal setting or legal framework that is already quite dense, let's say. So because we have the MA, we have the SA, we have Data Act, we have Data Governance Act, we have the Cyber Resilience Act. So there is a number of frameworks that cumulatively will deal with a lot of questions that are raised by digital. So it was important for us, first of all, think, okay, we are not doing ethics in the Commission, we are doing regulation. So we need first to extract from what is an ethical framework, what is actually should be rules. Second, we needed to take into account of the existence of other rules, like the ones I mentioned, and perhaps I would say the first I should have mentioned is GDPR. And GDPR already includes a lot of provisions regarding the processing of personal data, as well as, for instance, automated decision-making. This is an element that, of course, was already there, and we didn't want to interfere with existing legislation in that space.
And if I may, Gabriel, what you also had to do is, I mean, you said it in the beginning, you were regulating, I mean, with this risk-based approach, the use of the technology, not the technology itself. Yeah, so I'm regulating car, but don't mention cars.
Yes, yes, exactly. So then, perhaps briefly, because I guess we are a bit out of time, but on the second part of the question, I think about the industry search and find for smart solution to bypass your regulation. I mean, this is also a matter of course, the laws is there to be complied with, and companies should comply with. In a way, not everyone is law-abiding citizen or company. That is to be factored in. But that is indeed the goal of having legislation in place that is well thought through, well structured, well articulated in respect indeed of other pieces of legislation. And if this doesn't happen, we are giving a chance indeed to those companies or those citizens that are maybe less law-abiding actually find inconsistencies, loopholes. And so I don't think it's a matter of AI Act or non-AI Act, it's a matter of the quality of the AI Act.
Thank you. Maybe to come to our final question, maybe to give a bit of background, some critics say that the EU regulation is a compliance monster, and that, like you just enumerated, there are a lot of rules and regulations that companies have to abide to. Now, to pick up on what you said, Gabriel, that it's just one piece of the puzzle, the EU AI Act. I'm finally at the end of our panel asking myself whether we should, like Mark Rotenberg said in his opening statement, have the human in charge for the development and deployment of AI systems, and therefore a lot of regulation, especially in the legal sector? Or could innovation prosper even more if we just let the AI be the AI and keep the AI in the loop and not the human in the loop, like Mark Rotenberg suggested? What are your thoughts on that? Who wants to start? Ayesha, maybe you want to start because you already quoted Mark.
But I understood him differently. I thought that he found the human in the loop too little. He said, I mean, the human just being, I mean, overlooking AI is too little. So, I mean, the human must be fully in charge, and the AI is always the slave, if you wish, like the service provider, right, that is asking me what to do, and I'm the one who tells it what to do. I mean, but this is also, of course, only an image. I mean, and Gabriel has talked about, and we have talked about the problems of putting this into law and making sure that it happens the way we want it. And so you asked my question, I mean, does it help against bias? And I said it depends on what we make out of it. And that what I mean also by this, that this EU law also needs to put into national law, and we talked about and centers and TÜV and proving stations and ministries and other places to be designed first, I mean, that can do all these kinds of certifications and tests. And this is maybe where I'm most worried. Yeah, that we as Germans, we don't have enough experts, I guess, right? And this might then seriously stop innovation when we get the typical German, you have to write a paper, you have to apply for your AI readiness check, and it's not there, and then you have to call again and fax your statements and so on. So that is my greatest fear, that we are not agile enough in this risk self-assessment and so on. I mean, that if we make this, if we design this in a good way, I think then we can turn the AI into a prospering tool that gives security for investments, that gives security for human well-being, for transparency, for non-discrimination, for all the things we've discussed on the positive side. But this really has to be done then in a way I just discussed, so that we don't do it in this absolutely German angst-driven way. Don't do nothing wrong. Yeah, before we do anything wrong, we do nothing. If we do it in that typical German mode, then I'm really, really, really afraid. And I'm not saying that everything needs to be handed to AI, and that AI is always good. But as Mark said in the opening statement, we have many problems: communication problems, planning problems, cross-national problems. We have this labor shortage in Germany, and so on and so forth, where we need technology as a help. I mean, in solving our problems, and we should, and health problems, and supply chains, and so on and so forth. And there I see a chance, but there is also a window of opportunity that's closing. I mean, when we are all retired and we don't have technology in place, then it will be hard for Germany.
Thank you very much. Lillian, do you want to go next?
I don't. I mean, if you, as you might have already assumed, I do not think that we should leave the stage to the AI for itself, and just leave the stage and do nothing. I do think that the human has to remain in charge for a time I do not think that it should be indefinitely for all the times we use AI. That will not be possible. But I do think we have to use or implement human oversight and eventually replace the oversight by AI, so that one AI is overseeing another AI, and eventually perhaps leaving the AI for itself and leaving the loop completely. But right now, I do think that we would risk to just oversee all the biased decisions resulting in discrimination when we do not oversee the situations, because the AI itself is producing the outcomes in a objective and reasonable way. It is reasonable if it uses the databases provided, and when we do not, or if we do not oversee its decisions, we will just have to rely that the AI knows what it's doing, but it does not know what it's doing because it has no conscience. It has no, it cannot reason what it's doing. It's just a mission. So I do think that we have to stay in the loop and in charge for a long while to go.
Thank you, Gabriele.
So I think I personally I don't know if I would say the human in charge as opposed to human in the loop. I think the relationship that we are developing with this technology, I mean, this technology is already part of our life. Whether we like it or not, is that already entered. So now we are, in my view, as a society, adjusting to it. And I think the AI Act has been the response of the EU to find a way to control, to master, to make sure that we use this technology in accordance with our choices and our values. But I think we should not be ideological about this matter, but rather be quite practical. So, for instance, whether the AI should be in charge or human, or the human should be in the loop or in charge. If I think a little bit back, so I do a step back, and at the time of the GDPR, as I mentioned before, GDPR has a provision that allows automated decision making. What does it mean? It means automated decision making, solely automated decision making. It means, so it is, as a matter of principle, prohibited, but it's allowed in certain situations. So it's possible that certain decisions may have a legal effect on individuals or can have similarly significant effect, can be done in a solely automated manner by a machine, but then there are certain guarantees. So the fact that already in the GDPR was adopted, if I'm not wrong, in 2016, the fact that already at the time it was foreseen for that possibility, in my view, it's an interesting consideration to factor in the sense that we may not want to exclude the possibility there are situations where we could trust or we can allow certain automated process to make certain decisions for us, provided, of course, that those processes are trustworthy. And this is where the AI Act comes in. So we want to make sure that to the extent we delegate certain tasks to certain machines, then those machines are trustworthy. So, for instance, if we think about in a very sensitive area, like, for instance, the administration of justice. So I remember hearing discussions about robot judges is an absolutely no-go. We should never have allowed that. And I wonder, maybe the thing doesn't necessarily have to be a yes or no situation, in the sense that our administration of justice is sometimes completely flooded with procedures. So it's very difficult for humans to cope with the amount of legal cases that there are. And also ultimately, no justice is also bad, right? So the fact that we have to wait so long. So there may be opportunities, even in an area that people would consider absolutely no way that a human should not be in charge. where automation can really serve a good cause. Especially think about very simple or simple cases, traffic fines, where procedures tend to be always the same. So I would not be indeed in this sense ideological and say we should never use AI in certain situations, but we should make sure that of course the AI is as good as it can be. And again, this is where the AI Act comes in. But certainly, I would say maybe we should not use AI in a criminal case of manslaughter or something like that. So I think, but if we should indeed quite be, in my view, we should be practical about how we deal with AI and not really ideological.
Joscha, you want to?
Just a really quick thing. I mean, yeah, thank you. Just a really quick thing. The GDPR defines many terms. Yeah, what it talks about, it neither defines what a decision is nor what an automated decision is. I would really be interesting what the people thought what an automated or fully automated, you said, decision is. I have no idea what that actually means, but this is another discussion. So this is only the spoiler for our next meeting, I guess.
That's true. Thank you for that. And yeah, thank you all for summing it up and for your insightful thoughts and for taking the time this afternoon to participate in our panel discussion. There's a lot planned in the background, so thanks a lot, Alyosha, for the heads up. There's more to come. And also thank you to everyone in the audience for taking the time, and a big thank you to the whole team of the AI&Law conference, and especially my colleague Helena for helping to prepare this conference and the panel. And yes, thank you for taking the time and your thoughts. I don't know, Yannick, if you're already there, you want to add something? Perfect.
I'm here. Yeah, thank you, Ayosha, for the teaser for the next events, and thank you everyone for all of the speakers. You really made a great conference for us. I mean, we have to choose the people and we have to choose some topics, but in the end, you are the guys who fill out the whole event. So thank you everyone that you were spending the day with us, and I hope we see you next year. Yeah, thank you, and maybe next year or maybe in the next event. Jetzt nochmal auf Deutsch. Vielen Dank, dass ihr heute den ganzen Tag mit uns verbracht habt. Wir haben wirklich den Eindruck, wir haben hier heute viele Themen angesprochen, von denen wir uns auch erhofft haben, dass wir sie in dem Ausmaß diskutieren können. Insofern an alle Zuschauerinnen und Zuschauer, aber natürlich auch an unsere Teilnehmer und Teilnehmerinnen. Vielen Dank, dass ihr alle heute dabei wart. Im Namen von Recode Law möchte ich mich bei allen Sponsoren bedanken, die das hier auch möglich gemacht haben. Vor allem auch die Bucerius Law School hier in Hamburg, die uns das Studio zur Verfügung stellt und uns die ganze Facilities hier zur Verfügung gestellt hat. Ansonsten natürlich ganz großen Dank an unser Team, an unser AI&Law-Team. Ich glaube, diese Konferenz ist zwar dann immer nur einen Tag lang, aber es hat einiges an Vorbereitung gekostet, das dann so abhalten zu können, wie es jetzt heute ablief. Also vielen Dank an euch alle und ich hoffe, wir sehen uns nächstes Jahr wieder. Ich hoffe, dass sich alle KI-Systeme weiter so entwickeln, wie sie sich gerade entwickeln und dass wir nächstes Jahr noch wesentlich mehr zu diskutieren haben als dieses Jahr. Ja, ich hoffe, wir bleiben in Kontakt. Folgt uns auf allen Social-Media-Kanälen und wir freuen uns auf das nächste Event. Vielen Dank. Dankeschön.